and family and home. And for that, I'm sorry. I hope they forgive me and go on living their lives peacefully.
For that, I'm sorry. I hope they forgive me and go on living their lives peacefully. The apology met direct skepticism. Andrea Robinson said she did not believe he had fully taken responsibility. In a courtroom steeped in the pattern, the debate about belief gave way to sentencing math built on duration, motive, and danger. That is the legal contour Minnesota drew. Persistent harassment compounds culpability. The dangerous weapon elevates the assault. Property damage adds weight. When the conduct is racially motivated, the court reads the whole file through the lens of community risk. It treats the campaign, not only the crash, as the offense. Violations under these statutes trigger presumptive prison terms scaled by harm severity, yielding Bayer's 105-month aggregate sentence to deter escalation and restore victim security. So the question became whether the sentence would measure the 80 days or only the final act. You could feel the weight of justice settle as the terms were read. A family that had been forced into hypervigilance heard a boundary reasserted by the state. The law did what it is supposed to do when ideology slips into the neighborhood and tests the limits of safety. 2 courtrooms, 2 offenders. The third is global, a massacre framed by an extremist ideology, met by a sentence designed to remove any return.
Is a loner, a big fat loser, a coward and a pathetic human being.
What does a justice system do when an attack is designed to terrify an entire faith community at scale? In New Zealand, the answer arrived with a sentence the country had never used before, shaped by a legal framework built after 9/11 and tested by a crime planned to be seen, shared, and remembered for the worst reasons. This case educates on how post-global terror reforms enable courts to holistically prosecute ideological mass violence as assaults on collective identity and peace. Brenton Tarrant's 2019 mosque attacks forced prosecutors to use every lever the statutes allowed.
He intended to instill fear into those he described as invaders, including the Muslim population, or more generally, non-European immigrants.
It placed the conduct in a category that targets not only individuals, but the safety of a religious community. The courtroom treated ideology as evidence of purpose. Under the Crimes Act 1961, Sections 167 and 307, alongside